SJC-12183 in the matter of N.L.
Ms. Talley, good morning.
Good morning, Your Honor. May it please the Court, Karen Owen Talley on behalf of the appellant, N.L. Your Honor, in this case, we're asking you to construe a statute that provides for restraint on liberty and therefore should be strictly construed in favor of the respondent. The issue in this case is whether the trial court erroneously denied N.L.'s request for a continuance in his civil commitment and forced medication proceeding, and thereby deprived him of his opportunity to present a meaningful defense.
I'm just trying to, is your position that given the language in the statute saying that if the respondent seeks a continuance, that right is there, but not with the hospital in this case. Is it your position that the judge is required to give the continuance, or is it that an abuse of discretion standard?
Your Honor, we have two alternative arguments. Our primary argument is that due to the statutory language, which does, you're correct in saying that it grants the right of a continuance only to the respondent, that language deprives the court of discretion to deny the continuance. And that the
for any length of time?
For the length of time, our position is that at least with the statutory language, at least with respect to the initial requested continuance, the judge is required to grant that. If your question is...
If you ask for 2 months, that would be fine?
Right, I understand your question. So, first of all, I don't believe that in these cases, given the fact that the respondents are being deprived of their liberty and being committed and are seeking to leave the hospital, that you would have a situation where respondent was seeking to unduly delay the proceedings and asking for 2 months. I think most of these continuances are requested, as it was in this case, for purpose of additional time to prepare. However,
of the continuance would be the issue subject to the judge's discretion, right? I mean, you could say that they have an absolute right, but that would mean that you have a right to a 30-day continuance. That the length of the continuance would be up to the judge's discretion.
Correct, Your Honor.
Okay.
And that was what I was about to get to, which is that if the request was so unreasonable, say it was, a month that was requested, and there was no reason why that was connected to the opportunity to prepare the case, that the judge would have some discretion with respect to the length of the continuance or does have the ability to inquire.
Can I ask you factually, with respect to N.L., he was in a secure part of the hospital and would have remained secured had the continuance been requested, correct?
Correct, Your Honor. Anytime there's a petition that's filed, the individual is detained pending that petition.
And that's under Section 6, is that?
Yes.
So I'm trying to get to the practical aspects of the continuance. So
yes.
What this effectively did was delay the medication, correct?
If the continuance had been granted in this case, correct, unless somebody changed his mind, as patients sometimes do during the pendency, until there's an order of commitment that's entered, there cannot be what we call an 8B order to take medication. So yes,
You go ahead.
There can be circumstances despite that where medication can be given during a continuance in a crisis situation, though.
Correct, and that's what we've argued in our brief, that it's a false dichotomy to suggest that the hearing either had to go ahead without the respondent having the ability to prepare or address the safety concerns that the hospital raised.
What's the, Justice Lowe's question, what is the basis for the emergency, if the hospital comes in and says, the trouble with the continuance is we cannot control this person if we cannot give medication.
There's two, actually, Your Honor, and they both occur both are found in the Rogers decision, Rogers versus Commissioner of the Department of Mental Health, and Chapter 123, Section 21. There's two types. One would be what's referred to as a chemical restraint, if there's an immediate risk of physical harm, and that can be administered if those criteria, that there's an imminent risk of harm, can be met. The second one, which is permitted under the Rogers decision, is to prevent, and I may not get the language exactly right, but an immediate, irreversible, substantial deterioration of the person's mental illness, and that is permitted so long as the hospital is proceeding to court to get court authorization.
Right. What I'm trying to figure out is, and obviously there are significant interests at stake here. But what I'm trying to figure out is, if we were to grant your relief and say there is an absolute right to a continuance, would this actually lead to an increase in involuntary medications, because the hospitals would throw up their hands and say, well, we have this right. If they're going to continue it, we need to preserve the health of this patient, so we're going to go ahead with an involuntary administration of medicine. Is that going to lead to an increase of that?
I can't really answer that question. It's hypothetical. Again, we do have situations where somebody may be refusing treatment on one day, and even during the pendency, if the continuance was allowed, may change their mind, may begin accepting medication, or they could medicate pursuant to one of these two exceptions.
Can you just explain again what in the statute would give the respondent an absolute right to a continuance versus a discretionary, based on what the judge's discretion was?
Right. We think that the legislature has already struck the balance. The specific language appears in two sections, Chapter 123, Section 5, which relates the rights that the person has, the right to be represented by counsel, to present independent testimony, and the court may provide for independent medical examination upon their request. And then it says the operative language, the person shall be allowed not less than 2 days after the appearance of his counsel in which to prepare his case, and a hearing shall be conducted forthwith after such period unless counsel requests a delay. And then again at Section 7C, it says the hearing shall be commenced within 5 days after the filing of the petition unless a delay is requested by the person or his counsel. So it's that statutory language that we believe entitles the respondent to a continuance in the first instance. And the reason for that is that when the statute was amended in 2000, the time periods were greatly reduced. We used to have a statute where somebody could be detained for 24 days without any prior judicial review. In 2000, the legislature amended that statute. It reduced the time period from 10 days to 3 for the filing of the petition, and then from 14 days to 5 days for the holding of the hearing.
The amicus did a very nice job laying out that.
They did. Yes, they did. I agree with you.
But would there be a problem with saying, okay, no, it's an abuse of discretion standard? Practically speaking, would you be able to work with that?
If there was an abuse, if the court finds that it's an abuse of discretion standard, then we believe that under the cases cited and relied on by the appellee, we still would have the ability to, in this case, a continuance should have been granted, that it was an abuse of discretion in this case. The criminal cases that find that it was not an abuse of discretion to deny a continuance on the day of trial, as a general matter, as a group, seem to relate to a situation where the person has concerns about counsel and is requesting new counsel on the day of trial, but counsel is not otherwise unprepared. So we would distinguish those cases and find that even in this case, where even if under an abuse of discretion standard, the discretion was abused in this case.
I'm saying,
Yes.
assume it was an abuse of discretion.
Yes.
Practically speaking, do you feel like you could move for an emergency stay or something like that? Could you work within an abuse of discretion standard as opposed to saying, no, we automatically get our continuance?
I think so long as obviously, our primary argument is that the statutory language has already struck that balance that a judge would be required to balance under abuse of discretion standard. I think if the court decides that it is an abuse of discretion standard that applies, then in instances like this, where the respondent is requesting more time for the purpose of exercising the other rights that he's given under the statute to present independent testimony, and hopefully in the brief, Your Honors understand that all of these cases stand or fall on medical testimony. They turn on medical testimony by nature of the issues. So in this case, that was what was at issue. There was a general lack of time to prepare because the medical record had not been made available by the hospital to respondent until the day before the hearing. It was not made available until the afternoon of November 5th, and the hearing was scheduled to take place at 2 o'clock on November 6th.
Now, is it your position that the denial of the continuance here was a denial of the effective assistance of counsel?
It's an interesting question, Your Honor. I think potentially it can be a situation where to be denied a continuance is tantamount to a denial of effective assistance of counsel. We're not claiming that counsel was ineffective in this case. I think counsel did the best job she could have done with the time that she had.
Right, but isn't that
however,
I mean, that's the issue.
Yes.
Obviously, if the judge denies it, you've got to do the best
Yes.
you can.
Yes.
But, I mean, are you framing a position that counsel cannot reasonably be effective under these time constraints?
Correct. Correct.
And would it be your view then that it would be an abuse of discretion? I mean, I know that's not your first preference, but that it would be an abuse of discretion for any judge to deny a continuance where the continuance is necessary for the effective assistance of counsel?
Yes, correct.
Do we have to reach that, or is it more that it's a denial of the right for an independent examination?
I think that in this case there was, because again of the lack of the availability of the record, either with or without the issue of the independent evaluator, counsel didn't have sufficient time to prepare. But in this case, when an independent evaluator was obtained, and was obtained as quickly, I would submit, as humanly possible, given the time frame, that was a significant issue in the lack of
In a
preparation.
violation of your client's statutory right to an examination.
Correct.
But I wanted to go back to Justice Budd's point about what the decision would look like if we agreed with you, because the attorney may be very assiduous and want X amount of weeks to prepare for this hearing. You point out that the time that somebody can be held is becoming less and less and less.
Correct.
And I'm concerned, quite frankly. I understand why the request for the continuance here, you needed the medical testimony. But I am concerned that, that the judge might say, well, I don't really think that this person should be held for 3 more weeks to prepare for this hearing because counsel's asking for 3 more weeks out of concern that the person's being held. So going back to Justice Budd's point, what does the decision look like if we agree with your basic point?
I think that, again, there's a certain amount of protection that's inherent in the fact that the respondent is being detained, doesn't want to be in the hospital, so I don't think you're going to be faced with unreasonable requests on the part of the respondent. Respondents' counsel under CPCS standards are required to get their client's consent to any continuances and to ensure that the client is on board with that request. So I don't think there's going to be a lot of situations where counsel and their client are at odds in terms of the amount of time that's requested. But I understand your question about how do they exercise this discretion and prevent the person from being held.
I used to do these hearings when I was a district court judge, and the reality is that sometimes there is a divergence between what might be in the legal best interest of the client and what the client wants. And I wouldn't like to see any decision we make result in people being unnecessarily held, considering the purpose of the statutory changes.
Absolutely, absolutely.
Is part of your claim that in any event, the judge should be stating, if the judge doesn't grant the continuance sought by the respondent's counsel, that the judge should be stating her reasons?
Yes, I think that the case law demonstrates at least a strong preference for the judge to state his or her reasons if they're denying the continuance, so that it can be reviewed for an abuse of discretion and it can be reviewed for the balancing of interests that is supposed to occur. Although, again, our primary argument is that the legislature has struck that balance, and I think we do have case law that suggests in the criminal context and this context as well, that where the standard is beyond a reasonable doubt because a person is being deprived of their liberty, that respondent's interest is paramount.
Thank you.
Thank you, Your Honor.
Ms. Hall, good morning.
Good morning. If it pleases the court, Diane Garrity Hall on behalf of the appellee, the McLean Hospital in this case. The hospital believes that the statute is quite clear, that in sections 5 and 7, as counsel indicated, the language used makes provisions in terms that uses the word requests a continuance, and we believe that that term is a term where it's not an automatic right, that it's something that somebody has to go to the court to make that request, and the judge then can...
But it says unless. It says it will happen unless the person requests. So it doesn't, I mean, that could suggest that when the person does request, it doesn't happen in 2 days.
But again, I think it's got to go to somebody to make a decision. I think, as you were pointing out earlier, how much time is appropriate. We have cases, I've had cases over the years where people have asked for weeks, not days, weeks to get an independent.
But here she didn't grant any.
Correct. And again, I do want to point out from a practical standpoint, we get requests quite often from the hospital's perspective, and we look at a situation of what do we have in front of us? Do we have a situation where we have somebody who is really dangerous, putting themselves at risk of harm or not? And a lot of times we agree to a continuance.
But so here, since she didn't make any, give any reasons, but here it's the case that the patient was not going, I mean, if the continuance had been granted, the patient was going to be staying in McLean's, correct?
Correct.
So as Justice Gaziano said, is the question really about the medication?
So let me see if I can point this out. So when you have somebody with an illness that might be responding to voices in their head, right. They're very unpredictable, they're very potentially impulsive, they do things without anybody knowing what's going on because they're responding to something else that's going on in their head, can put people at risk of harm. And as counsel pointed out, the two things that we can do are restraints, or we can treat on an emergency basis. Well, we take that emergency treatment in the Rogers case very seriously, and we don't do that unless there is, life or limb type of situation. And we do that on a one-time basis based on what we have in front of us. Restraints can result in people getting harmed. Patients get hurt, staff get hurt, other people get hurt. That happens very often. And those are the types of situations that we look at. In this particular case, because of what this gentleman had been doing, making weapons out of what was on the unit, what he was getting his hands on, and it just kept going. It didn't stop. They were very, very concerned. He kept saying he wanted to run. He wanted to escape. He had already done that once. He was going to burn his mother's.
That was actually the question I had, and I'm not in any way trying to minimize the danger involved, or potential danger involved. But when I read throughout the record that he had a history of eloping and we were concerned, the fact remains he was in a secured part of the hospital and he couldn't.
Again, he was in the hospital and he had already done that once. So as much as we try to prevent people from doing...
When he went on through, there was some walk he was allowed to go on. And
he wasn't allowed. He got out.
Okay.
So again, as much as we can try to do, there are certain situations, and again, I'm not saying this is every case. This is an exception when we have very ill patients. And again, we think that it should be left to the discretion of the court. We think that it's up to the judge to make that determination based on what's put in front of him or her.
Given that, why wasn't this a problem? The hospital delayed in producing the records. Again, the court has this schedule that doesn't permit them to react quickly to a situation like this. I don't understand why that's not an abuse of discretion.
Again, we believe that in these cases, let me see if I can point out, there was two issues. Counsel claims they didn't get copies of the records. The records are on the unit and are available for counsel to review at any time. So if they request copies, then it goes into medical records, who then makes a copy of the record and provides that.
I totally understand that. But I mean, it just seems to me that there ought to be some quid pro quo here. If the hospital is going to be insisting on this expedited process, that they ought to cooperate with counsel in making sure that that happens. I mean, they had a physician to examine the patient the very next day, and you have this Tuesday, Thursday rule. That can't be a factor in deciding whether or not to give a continuance, that the judge is only going to show up on Tuesday and Thursday.
Again, I'm not sure I can answer for the court. It's just something that has been put together in many courts to accommodate court schedules, everyone's schedules, so you know which days you've got hearings on. We have lots of patients at McLean. We have lots of hearings. We have lots of filings. This is something that the court has done for years, is put a schedule in place to accommodate the schedule, and specifically when the timeframes were changed down to the 5 days to hold a hearing, 4, and then it went to 5 days to hold a hearing, the courts had to do something to accommodate that, and based on the number of petitions that we have, that's what they have in front of us. The legislature established the timeframes under these cases.
To further liberty interests, right? Not the hospital's interests.
Well, and the hospital did not object when that happened because it furthered their interests as well. So I think it was a dual, both interests of the hospital and the patients were benefited by the shortening of the timeframes. More insurance scrutiny is what we have nowadays in hospital settings. We have, patients who are ill and require treatment, and we'd like to try to do that sooner than later. And again, this is an exception. This is not the rule. This, opposing a request for continuance is not something that we do on a regular basis. We look at the situation we have in front of us as to whether there's a risk of harm, and then we decide whether we can assent to a continuance. We try to sometimes negotiate the time frame.
Well, I'm just trying to understand, what was the practical problem with giving counsel 2 additional days, or whatever it was that she was requesting, a short continuance? Why couldn't you agree to that?
Well, because the doctors believed that he was at imminent risk, that they were having difficulty containing him, and that they were afraid that he was going to come to some risk of harm or the staff were going to come to some risk.
So Rogers didn't help the hospital in that situation?
It did not.
Why not?
Well, if he had done something to warrant a restraint, then they could have restrained him. They could have medicated him. Again, on a one-time basis, that's what the Department of Mental Health allows us to do, is on a one-time basis. If it had been egregious enough, we could have looked at it on a regular basis. But again, when we have to restrain someone, that in and of itself is what puts people at risk.
But there's a conflict, it seems to me, or at least a tension between saying it's so bad we can't agree to a continuance, but it's not so bad that we could do something about it.
Well, again, we don't want to have to do that in every case.
But I mean, he's asserting a right under the statute, arguably.
He is. He did in this case.
And one that you could read as really being oriented toward the protection of his liberty interests.
But again, we believe that this is driven by the statute. The statute says counsel shall have no less than 2 days.
Do you agree that the right to counsel means the right to the effective assistance of counsel?
Absolutely. But again, given the timeframes, I think it's a different standard than in other types of cases.
Okay. And with regard to the IME, do you agree that the statutory right to an IME means an IME who has adequate amount of time to prepare?
Again, the timeframes are very specific in these types of cases. So,
but are you saying yes, but only within those timeframes? That if a judge were to determine that counsel reasonably cannot be effective, or that the IME cannot perform his or her job, that is not a proper
I'm
basis?
not saying in every case that a continuance would not be.
I guess my question is, do you agree that it's an abuse of discretion to deny a continuance where it would deny the defendant the effective assistance of counsel or the meaningful review by an IME.
But if counsel is saying, I think this kind of puts you down a slippery slope, where does it end? If counsel is saying that they require independent medical evaluations in every single case because the cases hinge on medical issues, then it would then destroy the timeframes that are established by the statute. If they required a continuance on every case, if they required an IME on every case, then you would never get a case that would be done within the timeframes that the legislature indicated.
Wouldn't the break on that be the judge's discretion?
Again, I think the court should balance what it has in front of it in a particular case and make that determination as to whether it's appropriate, balancing the interests of both parties.
But the balance, I mean, with all due respect, the balance seems to be with regard to the emergency giving of the medication here, that you want a judge to cover you. If you do it yourself, then it's on you as opposed to a judge. So, I mean, I understand that, but why should that affect the effective assistance of counsel?
So I'm not saying that. What I'm saying is that the issue, I think, in what we had in front of us in this case was that we felt that somebody was going to get hurt. So it's not...
And if someone's going to get hurt, isn't that a ground under Rogers for you to give emergency medication?
Again, giving emergency medication for somebody who doesn't want it can, in and of itself, put both the patient and others at risk.
That's what you were going to do. That's why you wanted to have this order, so you could do that under Section 8B, right?
I understand that, but the difference is on an emergency basis when something has already happened, and that's when DMH doesn't let us give emergency medication as a restraint unless something happens.
Do you agree that there should be an abuse of discretion standard that takes into account the concerns of the safety of the petitioner, the needs of the hospital, but also the needs of counsel in preparing?
I do, and I think that's what the judge should weigh. The district court judge who has that in front of them should weigh that as to whether they can make that determination or not. I mean,
should there be findings? I understand how busy the district court judges are when they jump out of first session and they run over to McLean Hospital, but should there be some sort of findings that would be subject to review?
There could be. I don't think that I would have an issue with that. Again, I think that I think that this is really a case where putting forth what the concerns are of both parties, I think, is important, and it should be up to a judge to make that determination.
Except that I do, I mean, it's not that I disagree with you totally, but the time frames in this statute are designed for the benefit of the respondent. I don't think there's any question about that. I mean, so that when the 2 days is supposed to be the hearing, that's not for the hospital's benefit. That's so that the liberty interest isn't restrained or implicated any more than necessary. So when you talk about balancing the rights of both parties, it's not so clear to me that this statute gives the hospital a whole lot of rights.
Well, again, and it's not so much our rights, it's more keeping the patient safe. I mean, I think it's really, that's the hinge that I see and that I argue when I have these types of situations. If there's nothing that, I mean, again, we have a risk of harm is part of the standard, I get that. But when you have somebody that is going over and above, doing something that is really quite serious, I think that that's where I take the position that at least it needs to be looked at, or the judge should make that determination. And again, it's not so much for the hospital, it's more for the patient, keeping the patient safe. And I think that the patient has a right to counsel, the patient has the right to present a defense, but I also think that the patient has the right to be safe too. And I think that that's really where the hospital's looking at this issue, and I think that the district court judge is in the best position to make that determination.
And you don't think that would be something that counsel would be concerned about too?
I would hope so.
Oh, I see.
I would hope so.
I'm still a little bit struggling with this Rogers framework. You go to the court and you go, Judge, you really can't postpone this because this guy is dangerous. Dangerous to himself, perhaps dangerous to others. And would that not be sufficient under Rogers? to give him emergency medication pending a ruling by the court?
I think that I interpret that Rogers provision as, you know, very, very substantial. And again, you know, I think you have a lot of patients that are, again, extremely unpredictable. They can just walk up to somebody because of something that's going
Well,
on.
you have a
in their
lot of
head.
patients like that, but I mean, but you wouldn't
That
basically,
defines your universe,
you
doesn't it?
wouldn't,
It does to a certain extent, but again, some more than others, and that's really where, when the clinician tells me this person is really imminently at risk, and again, they treat these patients all day long, this is what they do. When I have that kind of statement that's given to me, then I think I at least have to bring it to the court's
Are
attention.
you concerned that we may unwittingly open the door to more involuntary medications?
I do. I do. I think that's where things have changed over the years. You know, a lot of the state hospitals have closed. We've got, I believe, sicker patients, and I've seen it over the past 20 years that I've been doing this. Sicker patients. We have a lot of the state hospital patients that are in our facility that were never there 20 years ago. And so I think that we have that as well. And again, you know, this is not something that we do lightly. I think this is looking at each individual situation and looking at trying to protect the patient.
all right, thank you.
Thank you.
We'll take our morning break.
Court, all rise.